এক নম্বর, তারপর 3 নম্বর। সারাদিন ওটা লাগে। যে মাদ্রাসা কি তোমার? আমি আছি তোমার তোমার লোক এসছে আচ্ছা শোনো 28 তারিখে তোমার একটা আছে আমার 22 তারিখে তোমার চেষ্টা করতে পারো বাবার ভাইয়ের অপারেশন তো বাবার কাছে লাগে তোমার আমি দেখছি আমার অপারেশনটা হয়ে যাক তারপর আমি চলে যাবো, হ্যাঁ? আরেকটা অপারেশন আমি আছি নাতি আমাকে ডিভিশন মিলে ডাক না মানে কথা বলছি সিটি করলে আমাদের সাবমিশনটা কে বলবে কে ছিল সেকশন 5টা পুরো শুনে দিয়েছে সিটা করে কে শোনালো কে দৃষ্টি নেই তার আবার কি আসি তা আবার কে আছে মানে ওরা এক্সপ্লেনেশন করতো দেখো ঠিক আছে যেসব আমাদের ইয়ে করতে বলে যাবে another very but still it is a judge's best judgment I have a three judgment case আমি সাবমিশন করতে হবে রিপোর্ট হতে দিয়ে three judges best of info হরুল বেদবার আপনি বেদবার আমি ওটা দিচ্ছি কিন্তু এই একটা রেকর্ড খুঁজে পাওয়া যাচ্ছে না যেটা এক্সপেডিশন দিয়েছে আমরা খুঁজে পাই না যদি খুঁজে পেয়ে যেতে পারি তাহলে হবে পুরো গেলি না এটা আমাদের স্টে করছি এটা আনা হয়নি তো না বাড়িতে আসবে বাড়িটা বলে দিয়েছে related party that means the village only has the sort of there's the
Yes,
Correction.
correction. Yes, under this.
Lordship, may I,
Monday under the heading for correction.
Lordship, may I permitted to mention in terms of item number 36, Lordship,
Wait,
the long.
wait.
Can leave to mention one hearing matter group 2, your lordship, as my lord is taking the hearing irrespective of classification, your lordship. So mention this matter. The matter is of 2011, your lordship.
Have you served notice?
Not during the course of the day. I will serve notice.
Serve notice, then mention.
Lordship.
You allowed to mention under the heading application notice has been served.
What application, sir?
Substitution upon setting aside abatement.
Very good. So, Mongolbar ko দিতে বলবে application. Any other mentioning? Yes, call the list.
Lordship, item 36, Lordship.
Yes.
Mentioned. Yes, Lordship. It's a long pending matter, Lordship, pertains to a leasehold plot of land at Kolani. My plot.
So you want upgradation?
Yes, Lordship.
No, upgradation is not possible. You have to wait.
Kindly fix any day, Lordship.
No,
Any date,
I'm
Lordship.
sorry. Call the list.
But I appear for the alleged contempt
For the
numbers 1,
petitioner.
3 and 4.
I am for this container number 2.
Who is for the petitioner? Mara-
Or is there? My lord, if your lordship kindly sees your lordship's last order dated 16th of January 2025.
Give me a second.
হ্যাঁ আমি বলে দিচ্ছি হ্যাঁ তো
All the contemners are present.
Well, all the contemners are present. If your lordship kindly sees your lordship's order dated 16th of January 2025.
Yes, Mr. Selim has come.
He has come, my lord. But in spite of, my lord, we have searched our office record. Well,
Yes.
subject to correction by my learned friend, my lord. We have not been, my lord, on the last occasion, no rule was served upon me. My lord, I have served your lordship's
Yes,
file
yes.
also.
I'm told by my SEO that due to inadvertence, the file could not be sent to the
File could
department.
not be sent, my lord.
Yes,
That
yes.
is,
It is lying here.
my lord, I'm getting to your lordship.
Be that
But
as it may.
Now, my lord, but this appeal was taken up by the Honorable Division Bench day before yesterday, that is on 12th. Now, my lord, it was both of us, my lord, Mr. Bari was there, I was also there, my lord. It was heard, my lord, at length. Section 5 application, they have raised an objection with regard to the Section 5 application. The Honorable Division
The Honorable
Bench
Division Bench is seizing over the appeal.
decision over the matter. It was heard extensively. The Honorable Division Bench has made its CAV with regard to the Section 5 application. So the judgment is supposed to come today or by Monday, Tuesday, my lord. And Mr. Bari also assured, my lord, subject to question by Mr. Bari, that he will not, in the meantime, proceed with the contempt application.
No, no. This section 5 is being considered by the Honorable Division Bench. So let it be considered. Your lordship adjourn the matter for 2-3 days or 1 week.
Very good. Ashun.
Kindly grant us some time, my lord, because after if the
Yes,
Section
yes.
5
এই ওই রুলটা তাহলে আর ইস্যু হবে না, যেটা পাঠাননি সেটা আপনি আর যেন না হয়ে যায়, আর পাঠানোর দরকার নেই।
But in item number 2, I for the alleged campaign. This is appearing first time today. But possibly, my lord, my learned friend, my lord, is not correct. Kindly see your lordship for it. But a copy has already been served. My lord, my client, my clerk went to for affirmation, my lord, affidavit of service, my lord. It got stuck today, my lord. I will file, my lord. And if your lordship permit me, I can show your lordship the order.
Service is complete.
Absolutely,
But
they have
I
received.
have
But
not yet
my
received
clerk
a
went for
copy.
affirmation, my lord, and because the commissioner has not yet come. Both commissioners
Then I'm making it not today.
Can you keep it on Monday? Well, in the meantime, let a copy be served upon us.
already served.
You may serve a copy, sir. For this faulty matter, the court is not expected to intervene, sir. Not today. May only not today. Item number 4.
তোরা কি instruction নিতে পারবে না পুলিশ মারে করবে but can it be মানে some other day, because why I'm telling they will take copy, they will
Very good. Take down. At the request made at the bar, let this matter. Preferably written in same position. Yes, Mr. Dhar.
That today, maybe
Item
at
number 3 you are appearing.
3 and 4. In fact, this is the connected matters. Yesterday, Lordships kindly remember that Lordship passed an order.
Madrasa matters.
Madrasa matter.
Malik.
Same recruitment process.
Huh.
I cannot use the word that this is identical. This is connected in a sense. They are the affected persons.
So you approach the appropriate forum.
Exactly. That's I was about to say that Lordship has already passed an order
Well,
yesterday.
Huh.
With a little bit of difference, same order may be passed. Only difference may be this is a fresh matter. I have to use an affidavit in opposition.
So what do you want? There must be an indication, or you on your own
Well,
will mention the matter.
But what I want is that in fact I wanted to get hold of Lordship's yesterday's order, but it is yet to be uploaded. But as I remembered, Lordship indicated 2-3 things. Number one, which was there at last, that since these matters are before 2 coordinate benches, so Lordship said that any of us might approach the Honorable Chief Justice. That
I
part was
already approached, my lord.
fair enough.
I already approached. In spite of that,
But he
my
may not. He may not have the all records, because when I'm
yes,
appealing for-
I mentioned at least 15 matters.
No, what I'm saying you are appearing for the petitioners. Now, in every matter, as a Madrasa commissions, I would be the respondent.
Yes.
So that's the reason I requested my learned advocate and records that prepare a list, and once the order of your lordship is available, along with the order of the other honorable court, annex it,
Well, this is my
and
letter.
then write a letter to the
Well, one thing, my lord, here, I am for the petitioner. Lordship, kindly allow me 5 minutes only.
5 minutes.
3 minutes.
Very good.
My lord, I wrote a letter to the
in-
Honorable Chief Justice,
in
Secretary of the.
this, one lighter said, in this bench, 3 minutes equals to 30 minutes before other bench.
No, sir.
My lord, Lordship,
It
yes,
is.
my lord, get to the.
Very good.
Absolutely right, my lord.
I trust you. What is your
Well,
submission? What is your submission?
One thing, here in the instant case, 2 sets of petitioners have come before your lordship. But they are the cross all the hurdle. Only appointment letter.
Very good.
All the hurdle, my lord. My lord, not
I'm
only that,
adjourning
my
for
lord,
2 weeks. I'm giving liberty to Mr. Thor to approach the Honorable Chief Justice for
And
my
lordship,
lord, lordship only
assign before a particular.
one, my lordship. with
now let me
respect
take a
to my-
fair stand.
with-
No, favor. My lord, what my learned friend is saying, he is not unfair to say so. But the bone of contention is, we realized that on our part, there was a mistake in the process. Then we corrected it. Once we corrected, about 73,000 candidates, they come within the, I would not say zone of consideration, so that they can participate in the final written
Very
examination.
good. I am
on-
giving you a
No,
2
my
weeks
lord,
adjournment. In the
my lord,
meantime, if it is not come, I shall take up the matter.
One thing, my lord, one thing, my lord. My lord, one plea was given by the unsuccessful candidate before your lordship. 1 minute, my lord.
Yes.
That the matter is pending before the Honorable Supreme Court. And for that reason, my lord, time to time, my lord, the order was extended. My lord, my with due respect, I am submitting all, my lord, two
Mr.
petitions of-
Chattopadhyay, I am adjourning this matter for a fortnight. I am giving liberty to Mr. Dhar to approach the Honorable the Chief Justice for assignment. In the events, no order is passed by the Honorable Chief Justice in his administrative capacity. I shall take up the matter.
And my lord, one line
Take down.
clarify regarding my lord Supreme Court. my lord.
Both the writ petitioner and the respondent. Same order is item number 4, 3 and 4.
And
declare.
3 weeks.
28th October, 28th February is 3 weeks.
And
What
in
is the date?
But in the meantime, lordship, can you direct them to file the opposition? Otherwise, again, they will paid for opposition on that day.
Madam, what my learned friend is not able to understand, that what he's asking for,
I understand.
what I have not completed, what he's asking for, actually, we also want that. But there is a hurdle of ours because of your lordship's interim order. We cannot violate that.
Very good.
So therefore, our stand may be.
Come back on
But
28th. If you get an order, I shall take up the
I
matter.
direct them to file affidavit in opposition. Otherwise,
Not today, not today.
Declare.
Next.
হয়ে গেল, ঢবে চলে গেল।
But pay for the petition.
But I am for this.
Number on the last Friday, Lordship may recollect, Lordship had heard 2 disciplinary proceeding matters. This was I had submitted slightly different.
Yes,
So, my lord, may I just, I'll not trouble your Lordship too much today.
yes.
because the decisions will remain
Because
the
your
same.
lordship had already delivered
Oh, that's
judgment.
right, but there is slight difference.
But first,
The lordship is not inclined to reappreciate the evidence
That's right,
already. Your
that's right,
lordship.
that's right. Lordship had judged, but there is a slight difference. I'll only take little more of your lordship's time.
But I probably have intervened with regard to the
Quantum of punishment.
quantum of punishment.
No,
Lordship.
that is so far the pains and benefits concerned.
Pains and
Here, my lord, the punishment is quite different.
Very good. Let me hear it on
Lordship,
merit.
I'll be very brief. But may I just file the affidavit in reply first?
এই বইগুলো কিরকম ভাবে কে রাখলো? ঠিক করে সাজিয়ে রাখতে পারেন না আপনারা? হ্যাঁ?
কি বলছিস?
বইগুলো সরান এখান থেকে। এই কালকের বইগুলো, এগুলো যেগুলো অরিজিনাল সাইডে ছিল, সরান।
Well, I'm sorry.
থাক, ওই দূরে থাক, ওই দূরে থাক, ওই দূরে থাক। ওইগুলো থাকে, ঠিক আছে।
আলাদা রাখতে, হ্যাঁ? ACM মানে কি? ACM মানে কি? না, পোস্টটা কি? দাঁড়াও দেখছি। অ্যাসিস্ট্যান্ট চেয়ার। অ্যাসিস্ট্যান্ট চার্জ না। হ্যাঁ, অ্যাসিস্ট্যান্ট চার্জ। না।
Yes.
But may I just first point out the quantum of punishment to your lordship, then I'll take your lordship to the documents.
After the punishment?
Because lordship will see the quantum first, then I'll take your lordship.
Very good.
Well, the order of disciplinary authority starts from page 157. I'll just point out the quantum, then I'll come to the charge sheet. Yeah. 157 is the order of the disciplinary authority dated 10th March 2015. Now, lordship kindly takes page 160, the quantum. The nitty-gritties I shall point out. Page 160 is the quantum at the bottom. There are 3 punishments imposed. A is reversion to the post of assistant chargeman with initial basic pay with bottom seniority. His pay would be fixed at 6300 in the pay band of 6300, 20,000, 2,000, 200 with grade pay of
The
360.
relevant page is at
160. At the bottom, my lord, is 3 punishments imposed.
Yes.
But A is reversion to this post of assistant chargeman, that is ACM, with initial basic pay with bottom seniority. His pay will be fixed at 6300 in the pay band of such and such with grade pay of 3600. B is on completion of 1 year satisfactory service from the date of this order, he will earn his next increment from the stage to which his pay would be so fixed. And C, his seniority for the post of assistant chargeman will be counted at the bottom from the date of his joining to the post. So these were the punishments imposed.
So practically as if he has joined a new service.
As if new service. So, my lord, over here, my lord, before I take your lordship to the documents, my lord, my respectful submission will be 3 prongs. One, my lord, my endeavor will be to try to demonstrate before your lordship that the basic principle, my lord, which your lordships have held, that in a disciplinary proceeding, the preponderance of probabilities have to be established beyond doubt. That has not been done. 2, on the last talking matters also, I had taken the point circular has not served. Lordship had found that it was actually over here, admittedly not done. I shall take your lordship.
Very good. Show me.
Lordship.
First,
the charge sheet is at page
yes,
49.
I want to see the charge sheet.
At page 49. It starts from page 49. But I tell you, lordship, the basic allegation is that while he was in charge of the work of tree cutting, due to his negligence, allegedly 2 persons had died.
Page number 49, you said, no?
Without shit. I'm deeply obliged. Page 49 is the charge sheet. Well, it kindly takes page 50, page 50. Starts from page 50. But do not trouble your lordship, kindly comes to page 51. Kindly takes page 51.
Yes.
Well, kindly takes the second paragraph.
Yes.
Whereas it appears from records that though there was a scheduled program of cutting of trees of such and such inside the campus.
Sir, you are referring page number 51.
51, the second paragraph, my lord.
Whereas it appears
Lordship,
that
from the
there is
record
a-
that though there was a scheduled program of cutting of trees of KTTP Uluberia such and such line inside the campus on 30th November, September 2010, but neither any shutdown was insisted for by Sri Chakraborty, he is the petitioner, nor it was effected. It further appears that from record that as per prevailing norms and procedures of safety, every tree cutting should be done after taking proper shutdown of the line of this work can be tagged with some other line maintenance activities which are undertaken after taking shutdown to minimize interruption. Whereas on inspection of the site of accident, appears that the site was a dumping yard of KTTP and due to dumping of debris under the aforesaid line, ground clearance has been reduced to an unsafe distance. Even though on arriving at the spot and observing the physical conditions, Sri Chakrabarti being in charge of maintenance gang did not ask for required shutdown of the said line and instead of it, he engaged himself and other 5 maintenance staff to undertake the work of cutting of trees, endangering the lives of all the aforesaid members, including himself, which ultimately loss of 2 precious lives of the company's employees. Thus, it appears that Sri Manavendra Chakraborty SEM being
so,
Lord.
serious lapses.
serious allegation,
Yes, serious
Serious
lapses
allegation.
also.
being fully aware
Mr.
of
Kola, you will get your chance. Audio alternate partem will be followed.
No, I am grateful to your lordship. I know your lordship.
thus it appears that Sri Manavendra Chakraborty SEM being fully aware of the stipulations laid down in circulars, my lord kindly marks it. 2 circulars dated 30th March 2010 and 16th July 2011 of the chief engineer, my lord kindly, I'm at the sake of my lord, I'm repeating these 2 lines. Thus it appears that Sri Manavendra Chakraborty SEM being fully aware of the stipulations laid in these 2 circulars of the chief engineer such and such, and also the fact of not taking any shutdown of the KTTP, mobilize the technical staff. So this was the charge sheet. That due to my mistake, being the gang in charge, and I had not asked for proper shutdown, and I was aware of these 2 safety circulars, I had not asked which stipulated this, I had not done so. So therefore, 2 precious lives were lost. Now, my lord kindly takes page 53, the documents, the exhibits relied upon.
Yes.
My lord kindly straight away takes serial number 13, the penultimate from the bottom. At the last serial, see, serial 13.
Yes, sir.
My lord kindly first sees the line heading. List of documents by which the articles of charges against the Manavendra Chakraborty SEM attached to such and such is proposed to be sustained. Now, serial 13, circulars bearing memo number dated 16 July 2011 and 3rd March 2010. So these were the 2 documents also in the list of documents proposed to be relied upon.
Yes.
Lordship. Now, my lord kindly takes the findings of the findings which starts from page 71. I'm sorry, my lord, I'm sorry. Kindly takes page 51 to charge sheet.
Thus
Yes.
it appears that Sri Chakraborty SEM
Lordship.
being fully aware of the stipulations
Lordship.
laid in circular date such and such of the chief engineer such and such, and also of fact not taking shutdown, mobilize the technical staff of maintenance gang for tree cutting under the live line, endangering the lives of such and such. Very good. Then
Lordship. Now, my lord now kindly takes the findings which starts from page 71.
finding of the inquiry also.
Lordship. Page 71 dated 3rd July 2013.
Yes.
My lord, page 72, lordship will find again two my lord, club together. One is Govindo Biswas. We are not concerned with this. My lord kindly turns to page 74, the prosecution story against the petitioner. Page 74, Lordship finds prosecution story against the Manavendra Chakraborty. Now, my lord, kindly it comes to page 75. Well, about 16 lines from 15 lines from the top. The line starts with the date 01/01/2010, page 75. About 15 lines from the top, my lord, the line starts with the date 01/01/2010.
Mr. Pian, I request you to
Lordship,
come back to page number 74.
Lordship,
Uh,
Lordship,
you read from, kindly place from this place.
Lordship,
Prosecution story against Manavendra
Lordship.
Chakraborty.
Lordship,
1, 2, 3, 4, 5, 6, 7, 8, 9th line from the top of the said paragraph.
it appears from the job register.
Sir, please, please.
I'm deeply obliged. It appears from the job register, page number 131 of Uluberia such and such, that a scheduled tree cutting program in KTTP Uluberia on 30th September 2011 inside the campus of KTTP, and it further appears that according to that scheduled program, Sri Chakraborty, accompanied by 5 other technical staff of maintenance gang, reported at the spot on 8:15 a.m. which vehicle number such and such. It further appears that after reaching the spot of execution of the work of tree cutting inside the campus, that is the dumping yard, the aforesaid team of 6 technical staff divided into 3 small groups consisting of 2 in each group to carry out the work under the supervision of Sri Chakraborty. The 3 groups were such and such. The aforesaid 3 groups were deployed for tree cutting on the dumping ground at a very close and visible distance beneath the KTTP Uluberia in between such and such. It further appears that during execution of tree cutting works by the aforesaid 3 teams, which commenced around 8:30 a.m., the members of the other 2 teams consisting of Sri Manavendra Chakraborty and Zakir Hussain and Nimai Chandra Bera and Sri Tapas Chakraborty suddenly heard a loud sound with a flashing over the aforesaid line at around 8:57 a.m. Further, the aforesaid members of the 2 teams also found huge smoke surrounded at the workplace with fire at one particular place under the line. After the incident, the aforesaid members started shouting, calling names of the members of the other team to locate them and their whereabouts. In view of the non-receipt of any response from Sukumar Shatra and Shaktipada Mondal, both LM belonging to the same group, members of the other 2 teams started searching for Shatra and Mondal and found them in severely burnt condition near one burning tree under the said line. Sri Chakraborty and the others took Sukumar Shatra and Shakti Mondal first to KTTP hospital and thereafter shifted them to CMRI Kolkata, where Mr. Shatra expired on such and such and Mr. Mondal on such and such. It further appears from records that though there was a scheduled program of cutting of trees lying inside the campus on that date, but neither any shutdown was insisted for by Sri Chakraborty nor it was affected. It further appears from record that as per prevailing norms and procedures of safety, every tree cutting should be done after taking proper shutdown of the line or this work can be tagged with some other line maintenance activities undertaking after taking shutdown to minimize interruption. From the inspection of the site of accident, further appears that the site was a dumping yard of KTPP, and due to dumping of debris under the aforesaid line, the ground clearance had been reduced to an unsafe distance. Even though on arriving at the spot and also observing the physical site conditions, the Chakraborty, being in charge of maintenance gang, did not ask for required shutdown of the said line. So, my lord, these were the allegations. So, my lord, kindly see the charges frame at page 76. My lord, lordship is seen at the bottom, page 76, the charges framed.
Yes.
Sri Manavendra Chakraborty, ACM, having been fully aware of the stipulations laid down in the circular dated 30/10/2010 and 16/7/2011, being fully aware, and also fact of not taking any shutdown, mobilized the technical staff of maintenance gang for tree cutting under their live line, endangering the lives of aforesaid members, including himself, which ultimately caused.
So ultimately same. Is tantamount to act of misconduct and breach of discipline in terms of such and such.
Lordship, I am deeply obliged. So that was the allegation.
Yes.
Now, my lord, kindly turns to page. My lord, first of all, kindly turns to page 78. The exhibits. Starts from page 77. Kindly takes page 78.
Yes.
My lord, kindly sees exhibit number 14 and 15. The 2 circulars.
Exhibit number
14 and 15 at page 78.
Those have been relied upon.
Relied upon.
Those have been mentioned in the charge sheet.
mentioned in the
Those
charge
have been
sheet.
also been mentioned in
And it has
the
been stated,
charges.
and it has been stated that the petitioner is fully aware of these two circulars.
Yes.
Lordship. Now, my lord, kindly now takes page 107. The examination of the petitioner. This is the continuance of the, my lord, inquiry officer's findings.
Page number, sir?
107.
What is page number 107?
My lord, this is the continuance, my lord, of the inquiry officer's findings.
Yes.
Kindly see the second paragraph. My examination starts from here, the petitioners.
Yes.
Sri Manobendra Chakraborty, charged officer, was examined by Sri P.P. Go, his disciplinary authority, and cross-examined by the PO and DS, Sri Govindo Biswas. Sri Chakraborty stated that Sri Biswas did not make separate job allotment among the maintenance staff, and none of them was assigned with any specific responsibility by him. Hence, the instant tree trimming job was not his sole responsibility. That is number one. In their Uluberia such station, as per the practice of the substation, always fixed tree trimming programs. According to Sri Biswas, AE chalked out the program of the instant tree trimming executed on such and such, and he formed the gang consisting of Sri Chakraborty and other technical staff. Well, now kindly skips over. I shall not trouble your lordship. This is important. Kindly takes the third last line at the same page.
Yes.
Lord, there was no opportunity for any of them to supervise the work then. They did not obtain shutdown for the instant tree trimming, since in their substation all along there was no practice of tree trimming after taking shutdown. On 30th September,
not obtain shutdown for the instant in the substation. All
Lord.
along there was no practice of tree trimming.
After taking shutdown. On 30th
So
September,
keeping on it, tree is being trimmed. Trees are being trimmed according to him.
according to him, and those who are, my lord, I shall rely upon the evidences, the cross examinations. My lord, that was the, my lord, everybody examined says that was the procedure. I shall come to that, my lord.
Very good.
On 30th September 2011 and earlier, there was no record of tree trimming having been done with shutdown in the substation. He claimed that he had no opportunity of being acquainted with any circular
So
issued.
you are reading, sorry?
My lord, the earlier page 107, lordship had just seen this. They did not obtain shutdown for the instant tree trimming since in the
I was
substation.
seeing.
Now, it continues. On 30th September 2011
Yes.
and earlier, there was no record of tree trimming having been done with shutdowns in the substation. He claimed that he had no opportunity of being acquainted with any circular issued from the company, since he was not given or shown any circular in any matter. For a difference from the earlier two cases, specific submissions. Also, he was not given or shown any circular of the company directing that tree trimming has to be done only after taking proper shutdown. Neither any such circular regarding tree trimming with proper shutdown has been displayed on the notice board or anywhere inside the substation campus. On 30th September 2011, they undertook the instant tree trimming according to the instruction of Sri Govindo Biswas. He also stated he had not seen the circulars of such and such of the CE transmission regarding the safety matters. He claimed that there was no office order giving him duties and responsibilities of gang in charge for the maintenance work of the substation. He further claimed that it was merely an accident which occurred beyond their imagination, that it was not anywhere responsible. So, this was basically his examination. Now, my lordship kindly turns to page 111, the discussions and findings.
Yes.
Lordship has seen discussion and findings. The lordship sees the points have been jotted down. He says, before that, let us now jot down the points which seems to be decided for arriving at a rational conclusion. Lordship has seen the points. Now, let kindly turn to next page, serial point number 6. Page 112.
Six, seven, and nine are very vital.
I am deeply obliged, Your Lordship. 6, 7, and 9.
I believe so.
I am deeply obliged, Your Lordship. Page 112 there. Now, my lord, from the entire findings, but I have tried to find out, my lord, as far as serial 6 is concerned, my lord, I have, it is my fault, my lord, I have not found out in deliberations on this. Point number 6, my lord, I have not been able to find out deliberations. Now, my lord, kindly takes now page 125. Page 125.
Yes.
Kindly see the last paragraph. But I think this is important. We shall now discuss the above questions in the light of the facts and information which have emerged from the evidences of the PWs. 125, Dada. From the evidences of the PWs and the defense, the evidence of the Chakraborty, as well as from the job register and other relevant records maintained in the Ulubere station, it has already transpired that in the above substation, there was not a single instance of tree cutting or trimming after taking proper shutdown of the line. Admitted. He says it has already transpired that there was no earlier single instance of a tree trimming after taking proper shutdown of the line. Neither there was any record of passing written order by Sri Bishas, Gobindo Bishas, his officer, either for any maintenance work executed without pre-plan or for any tree cutting trimming work since executed in the above substation. It has only come out from the evidence of PW 1, 6 and 7 that only for planned maintenance work as per the norms of the company, before undertaking any maintenance work, necessary instructions through job register or otherwise from the office of the office holder is passed by the station in charge. But for the maintenance work of the substation, since executed, there was no practice of giving any such written order by the AE and station in charge of the substation from time to time, since before taking over the additional charge of the Ulubere station by Sri Bishas. What I am relying on this. Maintenance works were always done there through verbal communications of instructions, orders between the substation in charge and the gang in charge. Apropos to my lord, what that just fallen from my lordship, whether there was no record. He admits there was no practice, no records, nothing prior to this. Further, when the tree trimming program was going to be executed in the very next morning, there was no question of taking any initiative by Sri Chakraborty for obtaining shutdown from the SLDS DCC prior to execution. Will you kindly see this next line?
Just a minute.
I'm sorry.
Mr. Biani, I request you to come to page number 111,
Lordship,
111.
Lordship. Lordship.
In the last three points have been discussed.
Yes,
Whether there was a procedural program.
yes,
Next is whether on such and such date the delinquent was duly intimated and consulted.
Lordship.
And number 3 is whether according to the above purpose, consent of your client and other 5 legal tables was executed or not.
Lordship.
So consent was there.
Lord.
Now you come to 113,
Lordship.
second paragraph.
Yes,
The points numbers 1, 2, 3 may be examined and clubbing
Lordship.
together. Now ultimate finding is at page number 126, last paragraph, with regard to the 1, 2 and 3.
Lordship.
Kindly read that portion.
Now, I now therefore conclude from the above discussion with my opinion that the prosecution has successfully established the fact that the instant job of tree trimming on such and such was actually a pre-scheduled program, and that as per prevailing practice of the company, Sri Vishwas duly intimated and consulted the above program tree trimming with Sri Chakraborty, SEM and gang in charge. Number one, this is the finding. Number one, kindly seize page 125. His finding is absolutely contrary to this. Kindly seize page 125, the last paragraph. We shall now discuss the above questions in the light of the facts and information which has emerged from the evidence of the PWs and the defense evidence of Sri Chakraborty as well as from the job register and other relevant records. It is already transpired that in the above substation there was not a single instance of tree trimming, cutting after taking proper shutdown of the line.
No, sir. What I'm on,
Lordship.
so far as previous practice of tree cutting and trimming after taking proper shutdown was not included in the points of program within the point, rather issue number 1,
Lordship.
2 and 3.
Lordship.
That was not there.
No.
So far as the issue number 1, 2 and 3 are concerned, there
But he
the
has transgressed beyond these 3 issues.
very good. Ultimately, he has come to a finding with regard finding, and the decided is the issue number 1, 2 and 3 in favor of the prosecution.
In favor of the prosecution.
So, you just tell me
Lordship.
how this finding will be helpful for you when there no issues have been framed with regard to that.
No, my lord, I tell you, Lordship, my lord, I am deeply obliged to your Lordship, but my simple point over here is that his findings, own findings with regard to these points are contradictory at page 125 and 126. 125, my lord, and 126 what start, he goes on to say that there was no schedule of this like this, and he has only come to the that proper only for, my lord, there was no pre-planned over this. That is also already transpired from him. And now he also says after that, after discussing this, my lord, he goes on to say that there was a pre-scheduled program, and as per prevailing practice of the company, so there was, my lord, these 2 evidences, his findings rather, are contradictory in nature. 125 bottom and 125 bottom and start of page 126 and 126 the ultimate finding.
Probably you couldn't
I'm sorry.
understand my question.
I'm sorry.
Maybe it's for
No,
my,
not my fault, absolutely.
so far as issue number 1 is concerned,
Lordship.
the issue number 1 is with regard to whether there was a procedural program of trimming of tree on particular date.
Yes.
Number 1.
Lordship.
Issue number 2 is whether on the said day, whether with regard to that program, the delinquent was intimated or not. Just I am saying.
Lordship.
And whether issue number 3, whether the scheduled program was carried out with the consent of your client or not. So ultimately, rightly or wrongly, the inquiry authority has decided the issues in favor of the prosecution or in favor of the management, whatever term you may use.
Lordship.
Now, you want to show that the finding of the last paragraph of 125 is contrary to the 126 in as much as the inquiry authority has come to a finding, rather has come to a defining finding that from the evidence of the management witnesses and the defense witnesses, it would reveal there was no previous practice of cutting or trimming of trees after shutting down the lines. So
Also,
my question is,
Lordship,
how does it help with regard? How does it help your client? Rather, how does it how does it uh, considered to be a contrary with regard to the finding in respect of issue number 1, 2, and 3? Because the previous practice of shutdown of or discontinuance of the service line was not the issue under 1, 2, and 3. That I wanted to say.
I'm deeply obliged. Well, if subject to correction by your lordship, if it was not an issue, then at page 125, my lord, he should not have deliberated on this at all. In such
That
details.
you can say.
In such detail.
That you can
Because
say.
this is the basis of his finding at page 126.
That tantamount to consideration of extraneous.
External.
That you can say.
Yes, I'm deeply obliged. So therefore,
So you'll see.
so this discussion at page 125 culminates at the findings at page 126. Some of the basis is there. So he
No,
is considering.
it is not the so far. I'm sorry, I beg to differ, sir.
My lord.
So far as page number 126 finding is concerned,
Is
those have
schedule
been,
one,
those
two,
have
three.
been decided in favor of the management.
Lordship.
Ultimately, the finding with regard to the non-establishment of the previous practice of discontinuance of the line during trimming of
Lordship.
trees, whether it has been adversely affected the final finding of the, that you have to show.
That's right. So, but my lord, this was extraneous. 1, 2, and 3 does not consider one page, does not is relevant to page 125.
It is extraneous as regards issue number 1, 2, and 3 is concerned.
But it is also, as if your lordship takes it in the totality, it is in the totality, ultimate punishment, my lord, in page 125 is in my favor. As far as 1, 2 series number 1, 2, 3 is concerned, it is not relevant. It is extraneous. But ultimate finding, this page 125 is in my favor. Vis-a-vis the points taken by me in my examination that there was no scheduled program, there was no system of taking permission.
Will you repeat your submission?
But as far as 126 findings vis-a-vis the serial numbers 1, 2, and 3, if that is restricted to 1, 2, and 3, page 125 findings are extraneous.
Absolutely.
I'm deployed. Number 2, my lord, if your lordship takes in the totality of the punishment ultimately, then the findings at page 125 corroborate.
No, we will go to the
I'll come
punishment part of the latter stage.
I'll come to that.
You
Very
have
well.
to show that
Very
this finding influenced the inquiry officer
Very
in
well.
reaching to a finding with regard to the
I'll-
guilt of the.
I mean, I'll try.
That you have to show.
I'll try to do that. I try to. Number 2, next is kindly takes page 127, one line. But he has clubbed the second paragraph. We may now examine the points 4, 5, 6, and 7 clubbing together.
Yes.
But I am at serial.
Rather, issue number 4 is akin to the finding of the last paragraph of 125.
125.
That is akin
I'm
to.
deeply obliged.
Yes, sir.
Number 4, 5, and 6, and 7 clubbing together. But first of all, let me take series, point number 6, which is the circulars. Point number 6, lordship will find is the circulars. That your lordship will find at 112. Yes, page 112, point number 6 is the circulars.
Yes, yes.
Now, my lord kindly takes how he deals with that. Firstly, let me show you. Kindly comes to page 131.
বললেন একটু এসিটা বন্ধ করতে বলো, দরকার হলে আবার পরে চালাবেন। Yes, sir.
Well, kindly see the second paragraph. Again, as regards the allegation of violating the circular numbers dated 3/3/2010 and dated 16/7/2011, exhibits 14 and 15 respectively, regarding safety, display of safety posters in the substation campus and organizing of awareness programs, we find that PW1 stated that he could not recall whether posters in regard to observations of safety by the technical staffs were pasted on the notice board, walls, etc. of the office premises of the above substation. As regards the receiving of the above circulars, PW1 opined that the matter was beyond questioning since they were already widely circulated among the concerned officers. PW5 stated that during his tenure as additional CE Corporate Safety Division of such and such, various safety awareness programs were organized at Uluberia, which were participated by some staff from the distribution and transmission wing of the company, but he could not remember whether any staff from the maintenance wing substation also participated in the programs. He could recall that Zakir Hussain and Ainul were also posted at the substation and participated in such. He could not He could also remember that during inquiry, they found a safety awareness poster hung at the entrance of the control room. In this regard, PW7 stated that although he did not verify whether the above circulars have been actually received by the above substation, but he could remember that during the inquiry at the substation, they had seen safety manuals of the company. We find that PW2, 3, and 4, who were engaged in the instant tree trimming, had stated in their deposition that they had never seen any circular notice within the campus. PW3 supplemented that only during 2012 he found such a notice hung in the substation campus. PW4 also stated that prior to the instant accident, an awareness program on safety was organized from the distribution company office of the DDO, but he could not recollect whether he or any other maintenance staff of the substation attended the program. And my lord, kindly skips a few lines. The lines start about 4 or 5 lines. Line starts from 2 time. Same page, about 5 lines, 2 times only within the substation campus. About 5, 6 lines. The line starts with 2 time, then full stop. May I just
Page 132.
132. Only within the substation campus.
Yes, I got it.
Lordship. Only within the substation campus, a few hoarding had been put up about 3 or 4 years back, where companies' different instructions regarding safety measures also had been displayed. Now let us find whether what Sri Bishwa's charge officer Sri Chakraborty have stated. Sri Bishwa stated in his defense evidence as well as his written argument that during his holding of additional charge, he did not come across the safety circulars in the said substation. He of course stated that divisional officer organized one safety awareness program in 2007 in which staff from both the distribution wing and maintenance wing of the above section also contractors. Again in the year 2010, another safety awareness program was organized by the Ulubiria divisional officer, which was also technical staff participated. In his deposition in chief during defense evidence, Bishwa stated that within a few days of his taking over the additional charge of Ulubiria station, he took a meeting of all the technical staff of the substation, instructed them to compulsorily do all the technical work, including the maintenance work in the supply line, only with the shutdown and ensuring proper safety. In his defense evidence, Sri Chakraborty claimed that he had no opportunity of being acquainted with any circular issued from the company.
Come back to the first line.
Lordship.
In his deposition in chief during defense evidence, Sri Bishwa stated that within a few days of his taking over the additional charge of Uluberia Sachan station, he took a meeting of all the technical staff of the substation and instructed them to compulsory do all technical works, including the maintenance work in the supply line, only with shutdown and ensuring proper.
So that is his submission, one line. Lordship will find from the entire evidence and everything. Repeat. Kindly recollect page 125 again. Establish that there was no system, no written writing. Then what is subject to correction, my lordship? What is the veracity of this one statement when there is nothing written on no records? A statement made in his deposition without any records, where he himself, Mr. Bishwas himself says there is no records have been maintained. I have verbally stated this. When subject to correction, this cannot have a veracity.
Bishwas is another charge of a delinquent.
Superior to my petitioner in post. So he is shifting his responsibility. He on the one hand he says that there is no record, nothing was maintained. Then he says I had taken a meeting and instructed them verbally. And at page 125, the disciplinary authority finds that it holds that there was no record, no instructions. There was no practice. Now, kindly, if I may continue, in his defense evidence, Sri Chakraborty, the petitioner, claimed that he had no opportunity of being acquainted with any circular issued from the company since he has not given or shown any circular in any matter. Also, he has not given or shown any circular of the company directing that tree trimming has to be done only after taking proper shutdown. Neither any such circular requiring tree trimming only with proper shutdown has been displayed on the notice board or anywhere inside the substation campus. From the above, it appears that almost all the technical staff, including Sri Chakraborty or the maintenance wing of the substation, have just tried to plead their total unawareness of the safety guidelines of the company. Though it has come out from the above that from time to time the maintenance staff had come across them through the meetings taken in the office of the AE and the. That is all the discussions held with regard to the circulars. So the finding that there was no pre-schedule, there was nothing on record to show that the pre-schedule things were on record. Circulars specifically say not fine. The only the alibi is that sometimes some awareness programs were held. But that your lordships have held time and again, that the circulars or the documents they relied upon to my detriment have to be given over to the delinquent.
Mr. Bihani,
Lordship.
so far as page number 130 and 132 is concerned,
Lordship.
there is a detailed discussion by the inquiry officer with regard to the issue numbers, 4, 5, 6, I believe. And the inquiry officer,
4, 5, 6, and 7. Yes.
yes, 4, 5, 6, and 7. Inquiry officer considered the evidence of PW1.
Lordship.
He considered the evidence of PW5. So far as the evidence of PW1 is concerned, he stated that so far as the circulation, allegation of
Lordship.
non-circulation of the relevant circulars
Lordship.
is concerned, that is beyond questioning, since those are widely circulated among the concerned officers. So far as the PW5 is concerned, it is his version that during his tenure, various safety awareness programs have been organized at Uluberia such and such,
Lordship.
where such and such persons have participated. However, he could not remember whether any staff from the maintenance wing of such and such participated or not. And now, so far as the PW3 and 4, 2, 3 and 4 are concerned,
Lordship.
they have stated that they have not engaged they were engaged in the tree trimming process, and they found a notice in the substation with regard to the safety measures, which is hung in their substation.
Lordship.
Now, I'm coming.
Lordship.
Now, and in page number 132, the inquiry officer has considered the evidence as laid by Mr. Biswas and Mr. Chakraborty, the two delinquent.
Lordship.
Ultimately, the inquiry officer has come to a finding that the delinquent, who is the writ prisoner before
Lordship.
this court, is aware of that circular.
Yes.
Such being the supposition,
Lordship.
being in a judicial review,
Lordship.
how can I substitute my own
No.
view?
My lord, may I submit this? I followed for.
How can I?
Lord, I tell you, Lordship. My lord, invite your Lordship to do that on the ground. That over here, my lord, may I just try to draw? Lordship will decide that, but I'll try
Yes,
to draw.
Mr. Bihani, try to visualize the predicament of this
Lordship.
court.
I understand.
The inquiry officer has visualized the evidence of the various PWs.
Lordship.
Some of them are the higher officials and some of them are the workmen who are
Lordship.
on the relevant day, at the more specifically at the material time, was deployed in the management. He has also considered the deposition of the two charged officers,
Lordship.
the two delinquents, rather.
Lordship.
And ultimately he has come to a finding.
Lordship.
So, being a
My lord,
judicial review, what is the scope to
I'll tell you,
interpret
Lordship.
that?
May I submit this? But if your lordships find that in the findings arrived at are per se not correct, my lord, your lordships have time and again interfered. And why I submit this per se incorrect, I'll tell your lordship. But your lordship has gone through detailed in this deposition. I'm deeply obliged to your lordship. What has he found? He has held that. My lord, I'm not inviting your lordship to see the decision. I'm inviting your lordship to check the decision-making process. My lord, he has found that awareness programs were held. My lord, kindly takes it to be correct. Awareness programs were held. They were given in the awareness programs. My lord, it has to be mandatorily handed over to the delinquent, otherwise it is not correct. That your lordships have held time and again. And that is not, if that is not correct, then the decision-making process is incorrect. If the decision-making process is incorrect, my lord, lordships will definitely interfere in judicial review. He says, even if your lordship takes everything to be correct, they were awareness programs. That is also contradictory. Some says they were awareness programs, say they cannot remember if it was there, they cannot remember. Even if the lordship takes it in judicial review, lordship cannot enter, they were awareness programs, they were displayed in the awareness programs. The exhibits relied upon to my detriment, my lord, subject to correction, has to be mandatorily given to me, otherwise lordships will interfere in the decision-making process. And when your lordship comes to the appellate order, lordship will find the appellate authority specifically says there was no question of handing it over.
We will come back
Lordship.
to that. Very good.
So the decision-making process is incorrect.
Very good.
Lordship. Now, my lord, kindly takes my reply now at page 140. The 139, my lord, 139 is the finding of guilt. Page 139 is the finding of guilt.
Just a minute.
Lordship.
The inquiry officer
Lordship,
in page number 133
Lordship,
in the first paragraph,
Lordship,
1, 2, 3, 4, 5, 6 line from the
Lordship,
top, though all of them
Lordship,
admitted in their written statement that exhibit 6, 7, 8, and 9, that is, that in unsafe zone they always took shutdown for tree trimming. Actually, while discharging their duties, they did not follow the guidelines strictly and dealt with the matters most casually. As a result, they are not only caused the accident of the victim, but also endanger their own lives working in unsafe zone. According to his, is not a reasoned order.
well, reasoned order, well, subject to correction will depend on the how it has been arrived at. But if he is in one hand recording my submissions to that, my lord, he has to deal with those submissions. Lordship will not find him dealing with that. He says Mr. Chakraborty has taken these pleas, he was not given, he was not that. They were displayed in some awareness.
Mr. Biyani, the law is very subtle.
Lordship.
In a judicial review, if the court finds that there is an opportunity on the part of the inquiry officer to come to a different finding, a writ court cannot substitute their own finding.
No, I'm not inviting your lordship to substitute. Far from that.
Practically, you are invited.
Mr. Kohli.
But I'm inviting your lordship to exercise your judicial discretion, judicial review.
Mr. Biyani is making his best possible effort.
Yes,
his
yes,
client.
yes, yes.
So please allow him.
I am not interrupting.
No, I'm not.
I am not interrupting.
He has been
Only one point.
entrusted with the noble duty to
Naturally,
represent his client, and he is making his best possible.
No, I was
Irrespective of the fate of.
I was never
Please
interrupted.
allow him.
I was never interrupted,
Don't
Mr.
make
Biyani.
this
Your
high cover.
lordship
It's
has
very
got
unfair.
experience.
As is in high court.
No.
Please take your seat, sir.
No, but if your lordship, my lord, finds that the ultimately decision arrived at was based on factors which should not have been based on, or were based on factors which should have been considered but not considered. But my specific plea right through has been, I shall again demonstrate to you before your lordship in my replies, and the appellate when your lordship goes to that I have not been given these circulars. He records that.
Very good.
Then he says they were displayed. My lord, he had to give it to me. If it is not done, that is violation of principles of natural justice.
Very good. Next point.
My lord, page 139 is the finding of guilt.
Yes, sir.
Number of page 1440 is my reply. This is important. Kindly takes page 140 is a detailed reply. I shall not trouble your lordship with the entire thing. It's only a few paragraphs. Page 140 it starts. Number of kindly takes the last paragraph of page 140 and the first paragraph of page 141.
Yes.
Now, kindly see, once again I reiterate that as per telephonic instructions of Sri Govinda Bishash on such and such at about 3 p.m. 8 p.m. I think, for presence of the operating person of the control room, I was advised.
Page number 141.
140, my lord, last one.
What, sir? Yes. Once again, yes, I got it.
Yes, I'm clear. Once again, I reiterate that as per the telephonic instruction of Sri Govinda Bishash on 29 September at about 8 p.m. In presence 3 p.m. In presence of the operating person of the control room, I was advised to go on the training program of the following morning along with these persons.
Yes.
Accordingly, on 30th September 11, after reaching the spot again, after joint discussion, we were mutually divided into 3 groups consisting of these, and started the scheduled tree trimming works within the KTPP campus at about 8:30 a.m. Within a short period of resumption of the job, we suddenly heard a loud sound and witnessed flashing of these things. Then it has happened. Number of kindly takes page 142. And 142, the second paragraph.
Yes.
At the very outset, I like to state that among the three SEMs, in spite of being the senior most, I was never entrusted with the charge of gang by the authority. In my long service career, I have not heard the term like gang in charge. But kindly let there is no scope, there is no post of gang in charge. It is to be stated that in my substation on many occasions, other ACMs junior to me took shutdown with their own responsibility in spite of my presence, which be evident from the shutdown register. You can ignore. It comes to the last paragraph. This is what I was trying to place. That as regard to the circular dated 30th March 2010 and circular dated 16th July, mentioned in the findings of the inquiry officer, I once again reiterate that the undersigned had no
Mr.
scope to go.
BBML,
I'm sorry.
In my long service career, I have not heard that getting in my shutdown, in my substation, on many. Very good.
Now, kindly see the last paragraph at page 142.
Yes.
That as regards to the circular dated 30th March 2010 and circular dated 16 July 2011, as mentioned in the finding of the inquiry officer, I once again reiterate that the undersigned had no scope to go through any such circular, as the same was never circulated amongst the employees of the substation.
It is your consistent defense.
It is my consistent defense. Now, my lord, then I shall not trouble your lordship with everything. It will take time. Now, my lord, at page 146, lordship will find that I have stated that it was merely an accident and not to my negligence. Page 146. Lordship takes the second paragraph. About 6 lines.
Yes, yes.
And
purely accident and
lordship,
not attributed to act of negligence.
Lordship.
And carelessness of any single individual.
Now, my lord, page 148 is the second show cause notice.
Don't know why it has been captioned as second show cause notice. Ultimately, it is actually the finding of the disciplinary authority.
No.
Is it not so?
No, subject to correction. I'll tell your lordship why. Because kindly sees what he says at page 150.
Oh, yeah, is hereby given an opportunity to defend himself. Yes. Page 156, 148 to 154 is the second show
cause notice.
By the disciplinary authority.
By the disciplinary
Prior
authority.
to imposing punishment.
Lordship. Now, my lord, kindly takes page 151. Point number 6. The charged employee had no scope to go through the circular dated 16/8/2011.
Page 150.
151.
No.
Point number 6.
151.
Lordship.
Yes.
And this is the top first inquiry officer only stated the following points. He is quoting me. Kindly see point number 6. 16th August 2011. So, my lord, he has now come to one circular instead of 2. 30th September gone. He is quoting me, the petitioner, that I have taken this point. So, instead of 2 circulars, now it has been narrowed down to 1.
How it is prejudicial to you?
Because none of these circulars have been given to me. I shall show to your lordship. Kindly sees how he deals with this. Kindly comes to point, my lord, page 152.
Yes.
Kindly see the first line. As regards to point number 6 and 7. 6 is the circular. 6 and 7. Ignorance cannot be considered as an excuse while being a senior employee of the company, especially in the field of operation and maintenance segment. The office charged employee should have been aware of all the formalities towards the execution of human life. Therefore, his plea is not even rejected. Not given. Not handed over to me. I should have been aware. Well, this is complete admission. And if this is this provision, my lord, lordship will definitely invite your lordship to exercise your lordship discretion in the decision-making process. Because since 1973, 93, my lord, your lordships have categorically held that if any document is relied to my detriment, it has to be given to me physically. before the decision is arrived at. Now, my lord, kindly see the last paragraph. The misconduct is established against the SB very grave in nature concern, alleged officer. Accordingly, after considering of entire aspects of the case, including examination of previous service records, in an open mind, I propose to impose the following punishments tentatively. That page 152, my lord, the last paragraph.
Yes,
My lord, he proposes to impose these following punishments. Lord, you have seen that.
yes.
Now, my lord, kindly keeps this in mind and turns to page 153. Kindly sees the second paragraph, last line. Hence, I hold Sri Manavendra Chakraborty. Lord, she has got that. Hence, I hold Manav SEM guilty of the charges established in the departmental inquiry. Lord, kindly marks this. He is giving me a second show cause notice. He is proposing tentative punishments. He is at the same time holding me guilty. Lord, this is absolutely illegal, cannot be done. If you are holding me guilty, you have already made up your mind. So, therefore, the question of second show cause notice, the question of tentative punishment is only an I word. Kindly comes back to page 152 again. He has already found me guilty. But I'm inviting your lordships to enter into this in judicial review. He cannot do this. In page 152, he says, I propose to impose the following punishments. You give reply to this. And page 153 says, hence I hold him guilty of the charges established. And then he gives me the proposed punishment. So where is the scope of giving any reply to the second show cause notice at all? He has already found me guilty. It is in fact almost a post-decisional decision hearing. And second, I'm sorry, Lordship.
This is the second so cause notice,
Lordship.
whereby you have to read the last two paragraph of the
Lordship.
page number 54. However, before passing the final order, such and such is given opportunity to defend himself as such.
That's right.
So cause as to why the punishment proposed shall not be imposed.
That's right. And I'm deeply coming to that. So he has given me an opportunity to show cause to the second show cause notice.
With regard to the quantum of punishment.
So therefore he has found me to be guilty at all.
Of course.
But if he
Without holding guilty, how can he propose the
but
punishment?
your lordships have held that in the second show cause notice, you can give a tentative finding of punishment, not the proposed punishment. I've come with that decision. The proposed punishment cannot be, you cannot specify the punishment. You can only say that this can be tentative. Propose punishment and find guilty, you cannot hold him in the second show cause notice. That your lordships have held. But I know the limited conspectus your lordship has. I'm trying to invite your lordship to show, to try to demonstrate that this was an entire proceeding wherein, my lord, I had to be found guilty.
152 is a second so cause notice with regard to the proposed quantum of punishment.
That's right.
While doing so, the disciplining authority has come to a finding with regard to the proved charges against the delinquent.
Lordship. So therefore,
now he is going to propose, rather he is going to impose punishment for which he has sought for an explanation.
So my lord, therefore, subject to correction by your lordship, he is seeking an explanation for me with regard to the punishment only.
Oh, yes.
I'm limited to that.
Yes,
But subject to correction by your lordship, the second show cause notice cannot do so. The appellate authority can do so. The second show cause notice cannot be limited only to the quantum of punishment. The second show cause notice, my lord, subject to correction by your lordship, has to be open-ended in all respects. Otherwise, it cannot be a second show cause notice as it falls.
Can you show me any law with regard to that?
টেন্টিরি ওটা করা যাবে না সেটা টেন্টিরি ওটা করা যাবে না ওটা দেখ ওটা তো আমি আনি But I'll try come back with that. My lord, I'm sorry, possibly I do not have it
Very
right
good.
now. But I'll give it to your lordship. No, my lord, খোঁজ আমি ততক্ষণ ওটা প্লেস করছি একবার খোঁজ ও তো ছিল একটা আমার কাছে No, my lord, kindly takes my appeal at page 157. I'm sorry, 157 তো হচ্ছে
So, Mr. Biani, if I correctly heard you and I correctly recorded your submission,
No, lordship.
so according to you, second show cause notice cannot be limited to the punishment only. It must be open in all respect.
Lordship. And also, my lord, in proposed punishment, holding me guilty in the second short no is subject to correction cannot be done.
Now, how will
No,
we give
proposed
you?
punishment can be given, but he cannot find me guilty specifically.
That is your
Because
contest.
that is
It must be
contradictory.
open, absolutely
I'm
open.
deeply obliged, your lordship. Now, my lord, kindly sees the appellate authority's order starts from page 157. No, এটা তো appellate authority's order না এটা কার order বলো So the disciplinary authority's order that page starts from page 157.
With regard to the quantum of punishment.
Lordship.
Yes. Punishment awarded by
The disciplinary authority. Well, vis-a-vis which has just fallen from your lordship, I will just show one paragraph over here. Because I'll not trouble your lordship repeating everything again. He has repeated the same things in the inquiry officer. Can you take page 159?
Yes.
And this is the last paragraph. The reply dated nil. I'm sorry. The reply dated nil to the second show cause notice submitted by Sri Manavendra Chakraborty has been received and carefully considered. His past service records have also been examined by me. I have duly considered the instant reply dated nil to the second show cause notice submitted by the charged employee. Then, on consideration of his reply, I find that the charged employee has mentioned the same argument which he submitted in his representation dated 21st August 13 on the report of the learned inquiry officer. But I'm pausing here for a moment. So, the disciplinary authority has gone through my reply. He found that I have mentioned the same arguments over again. Well, so in fact, subject to correction by lordship, he is reappreciating the entire thing. When the second show cause notice has already found me guilty. That is contradictory, cannot be done. Kindly, may I repeat myself again?
Very good. I understood.
I'm deeply obliged to your lordship. Dekha. Kunta dekha. 18 kunta dekha. Well, just gives me 1 second. May I, as has fallen from your lordship, may I try to place a decision? Just copy the judge. Huh? Wow.
Very good. Let us conclude on the factual aspects. Thereafter,
Lordship, now, my lord, if lordship has got it, now, my lord, kindly takes my appeal at page 161.
Yes.
With all the points taken, everything taken. Kindly see the last paragraph at page 161.
Yes, sir.
Kindly see the last paragraph. So, responsibility of undertaking the tree trimming job on such and such as per instruction of AE Mr. Govindo Vishwas was carried out by me as a disciplined worker. Hence, there arises no question of violation of circular dated 2011 as alleged. Reference to the said circular, which could not reach the operational personnel, is grossly unfair. The authority has specified that my ignorance about the circular constitutes a plea for avoiding the responsibility. I admit ignorance is no bliss, but at the same time, there must be due procedure to get the workers conversant with the guidelines specifically. Unless the said usual procedure has not been meticulously followed from the authority, it will be grossly unfair. So, I have taken this point. Now, one point which I have taken in this appeal, not earlier anywhere stated or discussed with the appellate authority, is page 162, point number 9. Lordship will consider whether this is, but they have taken this in appeal. Kindly see point number 9. To victimize the undersigned by hook or by crook, the authority has cited many concocted stories. Kindly ignore this. For example, the incident of an accident related to tree trimming which occurred on as mentioned in my second shock was noticed, and also in the order dated such and such. You will be surprised to know that the undersigned had no relation with the accident which took place on 18th October 2010 in KTPP Baripada. As alleged or at all, I am still in dark why I have been held responsible for the said accident which happened under the jurisdiction of Kolaga transmission when the undersigned was posted at Uluberia. Second shows no cause notice mentions this incident where I was not posted at all.
Yes.
Now, my lord, page 164 is the appellate authority. That is the last document. My lord, kindly takes point number 2. The committee has observed that the appellant has put forward the following main points. Point number 2. Circular number 1278 regarding safety issued on 16th August, which is only 1.5 months prior to the mishap. Kindly marks it here. Lordship has got point number 2.
Yes, sir.
The circular is dated 16th August 2011, which is only 1.5 months prior to the mishap. And the circular never reached the substation. Therefore, the following conventional 30th theme or 14. So, I'm pausing here for a moment. If this was only 1.5 months before the mishap, the earlier, all the evidences that the awareness programs were earlier held, this circular could not have been there. It was only 1.5 months prior to the incident.
No, it is your submission.
Correct. So, kindly see how it has been dealt with now. It is my submission. Kindly see how it has been dealt with now.
The appellant has put forward the main point for
Correct,
consideration of the
I am
court.
deeply obliged to your lordship. Now, kindly take page 165.
Page?
165, the last page.
Yes.
Kindly, after point number 8, kindly see on consideration of the entire records.
Yes, sir.
On consideration of the entire case record vis-a-vis the contention of the appellants, as above, the committee has observed that the defense grounds under serial numbers 1 to 6, as raised by the appellant, had been duly covered by the learned inquiry officer inquiry report. Further, the appellant was first given opportunity to submit his representation. The committee has gone through the representation. End. My lord, subject to correction, where is the independent application of mind? 1 to 6, we have gone through the records, seen the inquiry officer's report, finished. Then he goes with 7 and 8. No discussion at all. My lord, this is subject to correction, ideal case for judicial review. The appellate authority will not apply its mind to this. Only one line order, I have gone through this. Now, may I place the next paragraph, my lord, regarding point number 7 and 8.
Just a minute.
Lordship.
Mr. Bihani,
Lordship.
we are taught by our seniors
Lordship.
that when we read a judgment,
Lordship.
it is to be read as a whole,
Absolutely.
not in a piecemeal manner.
Absolutely.
So far as, since you have drawn attention of this court to that paragraph, just after clause number 8,
Lordship.
on consideration of the entire case record vis-a-vis contention of the appellant as above, the committee has observed that the defense grounds under serial number 1 as raised by the appellant has been duly covered by the inquiry officer in this inquiry. That means the inquiry officer has considered those.
Not.
Right or wrongly, there is a discussion. Further, the appellant was given the first opportunity to submit his representation on the report of such and such. The committee has gone through the representative such and such. it does not end here.
No,
Thereafter, he discussed the other points.
right,
Then he comes to the finding.
Lordship. Kindly seize the findings.
Yes.
On perusal of the total records, the committee is in full agreement with the views of the learned DO as well as the disciplinary authority, has observed that the misconduct related to neglect of his acting deliberately be engaging teammates in undertaking trick without taking shutdown as well as preventive measures in violent defense of the, therefore the committee is of the opinion. This is the finding. So point numbers 1 to 6 taken in my appeal referred to, where is the discussion on those points, my lord, subject to correction? Subject to correction, my lord, I repeat my submission that these points, if I have taken in my appeal, has to be dealt with separately. They can not, or can be dealt with club together also, but there has to be a discussion. My lord, kindly cease the discussion. My lord, the committee is discussing on my livelihood.
Strict procedures, strict following of the strict procedure of the Code of Civil Procedure.
No, I'm not on Code of Civil Procedure.
Not,
My lord, absolutely not on Code of Civil
in-house
Procedure.
proceedings.
No, I am not on that. I am aware of that, my lord. What I am submitting is, Lord, may I just like to make myself clear. What I am submitting is that when the appellate authority is
On
the committee.
perusal of the total records, the committee, that's the appellate committee.
Yes, is in full agreement.
Is a one-man
It may be in
committee.
agreement.
Agreement with the views of this such as the inquiry officer as well as the disciplinary has observed the misconduct leading to neglecting his responsibility, acting deliberately, willfully by engaging its teammates in undertaking treating job without taking shutdown, as well as preventive measures in violation and defiance of the company's established guidelines, causing loss of such and such, has decisively proved in the inquiry. Therefore, the committee is of the opinion. It may be short.
No, it's not short.
It's
Well,
non-considerate.
it's not short. If they had clubbed it together and decided on that, this is your point, this is not correct because of this. But I would have understood it is short. Well, kindly see, there is no discussion at all. Your lordships have held time and again that discussion, the appellate authority has had to, my lord, apply its independent mind. Well, there is no independent mind. There is no independent mind. He takes 1 to 6 together, says, I have discussed this. Your representation has been considered by the disciplinary authority. In details, we agree with him.
Very good.
Lordship. Well, those are the factual situations.
Right.
Judgment of Well, may I just hand this over to your lordship? Well, this is reportable. This is reported in 2007 SCC online. Copy nahi. Oh, my lord, the earlier file had handed over this to your lordship. I'll give it to you.
No issue.
2007 SCC online Calcutta 293. Paragraph 18.
Yes.
This is also possible in CHN. I shall give you a lordship. I'll just read paragraph 18 and edit your lordship.
No issue.
Well, this is little marked by pencil. Kindly.
No issue.
It is settled law that this is only one paragraph I'm placing it. It is settled law as has been laid down in the decision cited on behalf of the petitioner that a disciplinary proceeding is initiated in order to ascertain as to whether the delinquent employee who is charged with misconduct is guilty or not. Burden of proving that the employee is guilty normally is on the management or employer. It is only after an inquiry is conducted in accordance with the principles of natural justice and a report is submitted by the inquiry officer holding that the charges of misconduct leveled against the employee stand established, that the employer can enter into the arena of considering whether the delinquent employee is to be retained in service or not while retaining in service to impose any other punishment on him which is permissible in accordance with the rules. Question of dismissal of the delinquent employee would arise after the employee concerned, having been found guilty of misconduct, warranting major punishment, gives his reply to the report of the inquiry officer holding him guilty, or where there is a provision for issuance of second show cause notice. The petitioner is forwarded the report of the inquiry officer together with the employer's tentative agreement with the finding of the inquiry officer. Not final. I do not. Over here says I hold him guilty. Tentative agreement with the finding of the inquiry officer and the provisional decision taken by the employer to punish him. Broadly, thus this being the procedure for holding a domestic inquiry, it is undesirable for the employer while issuing show cause notice or charge sheet to indicate therein that the employee sought to be proceeded against is to show cause against dismissal, termination from service, and thereafter to grant opportunity to the delinquent employee to appear before an authority for personal hearing. The possibility of a delinquent employee being of the impression that the disciplinary authority having already taken a decision, the inquiry proposed to be conducted against him would be one to complete a formality in law cannot be ruled out. Hold on, relying on this.
That is covering your contention.
No, that is covering my contention.
Okay, give me.
Lordship. Well, I'll give a fresh copy. This is marked.
No, it will serve my purpose. देखिए भाई ओटा किंतु
এটা হাত বাড়িয়ে দো না রেফার করে দেবো, একবার করে রেফার করে দেবো, আদার সাহেব দেখে নেবেন, শেষ করতে হবে। ক্রস এক্সামিনেশন দেখাবো না? জানি। হুম? আমি কি করবো? কোনটা দেখতে হবে? কোনটা দেখা? এটা করতে পারবেন তাহলে 61। আচ্ছা, ক্লিয়ার রকম রয়েছে। 61 লাইফ ইন্স্যুরেন্স।
Subramani, I request you to read some lines of paragraph 19 also.
দর্শক
এটা দিয়ে দিন। Don't think that the court is biased.
No, no, of course. You can show me, you
This
can
court
refer
never
the
biased.
materials or record the rules. We can reply to the sequence of the application.
The Honorable Coordinate Bench
Lordship,
has also discussed
yes,
that in the reply to the show cause notice, your apprehension with regard to the tentative biasness has also to be discussed.
Lordship.
That you have stated, that you have discussed. Because it is your contention that he cannot come to a definite finding with regard to the charges proved. It should have been a tentative finding. So this biasness must be reflected in your reply in paragraph 19.
Note of later, second show cause notice. Well, lordship is, is following from a lordship that the reply to the second show cause notice.
Yes, sir. That is starting from page 161. Have you read the next paragraph, paragraph 19, sir?
Yes. No, page 161 is not the reply to the charge sheet. Second, page 61 is the appeal.
I'm sorry.
Memorandum of appeal. The reply to the charge sheet is not annexed.
No, page 161, your letter. Appeal from exoneration of punishment.
So this is appeal before the appellate authority.
Oh, appeal before the appellate authority.
Income manager is the appellate authority.
Page 155.
Representation on second show.
Thank you. Right.
I'm sorry, it is the disciplinary authority, no?
No, this is not complete.
My lord, page 155 in his reply to the second show cause.
155 the read, but this is one page. The other pages are not annexed.
This is your read petition, sir.
Page number 153 is the finding regarding finding of the appellate disciplinary authority with regard to the guilt,
Lordship.
and accordingly he proposes to give a punishment.
Yes.
Give a proposes to punishment for which you have been asked to say I reply to the second show cause.
Lordship.
Page number 155 is your reply.
It's not complete. Kindly see if your lordship reads the last line. It is clear. Hence, there arises no question of violation of finish.
That I don't know.
My document. My document.
Your read petition.
Very good. That's all, Mr. Piani. Any other point?
No, regarding two decisions about non-supply of documents.
Okay, give me that side.
This citation. Oh, this. I'm sorry. Right. That's.
Mr. Kole, I am giving ample opportunity to Mr. Biani, rather to Mr. Biani's client, considering that he's dealing, this court is dealing with the bread and butter of that.
No, well, so far your lordship is concerned, because we have an impression in the bar that your lordship is not quite different from, so far the disciplinary proceeding is concerned, and your lordship's lord is, so far I am concerned, my lord, that your lordship has enough experience that where is the scope? That is why, my lord, but I am not interfering, my lord.
No.
On earlier occasions also.
Absolutely.
Because my learned friend submission, my lord, all along my learned friend submission, that circular has not been supplied.
Anything more?
Ultimately in his, my lord, appeal, he himself admitted that yes,
Admitted key.
it has been given to you.
Where are they admitted?
Anything more?
Well, to sum up the submissions, my lord, is I would say, my lord,
There is no repetition. I am noting it down
I followed
everything.
you, lord. Completely. We have Parata ball? My lord, may I just referring to one decision,
Yes, sir.
2006, 3 Supreme Court cases, page 150.
2006.
6, 3 SCC, page 150. এখান থেকে বের করা যাচ্ছে,
Page number, sir?
150, my lord, paragraph 18. এটা দিয়ে দাও। না না, এটা জজ সাহেবকে দেবেন। Thank you. হ্যাঁ। আর কিছু দেখাস না, এটা দেখছি, এটা করে শেষ কর। Paragraph 18, my lord. At page 159. Well, in our view, non-supply of documents on which the inquiry officer does not rely during the course of inquiry does not create any prejudice to the delinquent. It is only those documents which are relied upon by the inquiry officer to arrive at his conclusions, the non-supply of which would cause prejudice, being violative of principles of natural justice. Even then, the non-supply of the documents prejudice the case of the delinquent officer must be established by the delinquent officer, is settled by law. So, my lord, I would make the submission that the assumption that safety measures were taken and, my lord, they were displayed over would not suffice. It had to be given to me. Right. My lord, those are mistakes.
Yes, Mr. Kole.
At this. Tired age.
My lord, তো কেসে কিছু নেই, জেনেও তো তুই সারাদিনটা নিয়ে নিলি। My lord, so far, non-supply of circular is concerned, my lord has been saying. Your lordships has already, my lord, seen at page 64 in his own appeal, point number 2. Page 164, point number 2.
Yes.
It is an admitted position that he well known about the circular. I am coming that apart. I am coming. Circular number such and such was issued, which is only 1.5 months prior to mishap. The circular never reached to the substations, therefore following the convention such and such. So it was within his knowledge prior to that, prior to mishap. Next, I am coming. So this circular, so far the my lord disciplinary proceedings, rules of disciplinary proceedings, violation of rules of disciplinary.
No, he has taken the point that the relevant circular never reached the substation.
Yes, that can't be. That can't be. I'm coming. My lord, never reach the, forget about, my lord, for the time being. Your lordships forget about, there is no circular. Assuming there is no circular.
Then I have to go by the practice.
He is not practice, my lord. He is in church. He has been entrusted a vital job, trimming of trees inside this, my lord, the power stations, where, my lord, the live 33 kV, 133 kV, my lord, even a single touch, everything will be, my lord, as rather. My lord, it is not his duty to take care the job, taking shutdown and the work to be done. Forget about circular, my lord. I am entrusted a job. I am not, my lord, in a position to, my lord, take care of the job, how it has to be, my lord, carried out. Number one. Now, my lord, your lordships, my lord, kindly, your lordship did not trouble me in my affidavit in opposition. So far, the, my lord, circular and all these things, my learned friend is saying. My lord, in my opposition, page 13, well, being a senior employee, may I put into a question to myself, my lord? Being a senior employee, Lord, he is not in a position to, my lord, acquainted with the company's rules, norms, circulars, regulations. Yes. Specifically, my lord, when 56 of the 59 of regulations, my lord, it has been clearly stated that all the employees, being an employee of the company, was responsible to observe the rules, procedure, and all matters, also abide by rules, regulations, orders, circulars that may be issued time to time. But I am a senior employee of the organization. I am taking plea that I am not acquainted with the circular. But is it believable?
Very good. Next.
Next point, Milord, my learned friends took Milord that guilty. The second so. Yes. Milord, where is the Milord order disciplinary authority held him guilty in the second so cause? My learned friend says prior to tentative proposed punishment held him guilty. No, it has been stated it is observed by me. Your lordships kindly come to on page 53. Each and kindly come to page 153. It is observed by me that corroborative deposition of PWs, exhibits, documents, and such and such. Therefore, I fully agree to the findings of the learned inquiry officer, and I find all manners charged have been proved both eventually and documentarily. Hence, I hold Sri Manavendra Chakraborty ACM guilty of the charges established. It is not his proposed punishment. It is not the punishment that.
No, Mr. Bihani is not on that. Probably have not heard him properly. What Mr. Bihani is on, that while issuing this document, second so-called notice,
Tentative.
The disciplinary authority ought to have disclosed that it is his tentative.
Yes. Kindly come to
Listen to me,
next
sir.
paragraph.
Listen to me. It is the contention of Mr. Bihani. It may be right, may be wrong. That will be decided at the time of passing judgment. That while issuing the second so-called notice, the disciplinary authority ought to have come to a tentative finding with regard to the proof of the charges, and in that fashion he ought to have proposed the tentative punishment.
Yes.
Here the contention of the writ petition is that while by arriving at the guilt of the delinquent, the proposal for imposition of punishment is merely remains technical in nature, because he has already fixed his mind.
No,
That is, he was determined to give you punishment.
No, subject to your lordship's kind consideration. The next paragraph. In an open mind, I propose to impose the following punishment tentatively upon Sri Manavendra Chakraborty.
Try to understand what is his argument. His argument was that while second so-called notice, the disciplinary authority ought not to have come to a conclusive finding.
There is no conclusive finding, Milord.
With regard to the proof of the charges also. That is his contention.
No, Milord, unless.
Which shows that his mind was predetermined to impose punishment.
No, Milord, to that effect, subject to your lordship's correction, Milord, unless, in my, Milord, in this way, unless.
The contention of Mr. Bihani is that the disciplinary authority is such an authority who according to the law is required to reappreciate the entire evidence and to come to a tentative finding with regard to the charges, and at that material time, while issuing the second so-called notice, he ought to have given the proposal for tentative punishment. And after receiving the reply to the second so-called notice, he may come to any finding.
Subject to yes, it is subject to correction, Milord, unless the charge has been proved, Milord, I cannot propose tentative punishment.
So I understand that. So according to there is no illegality in correcting this fine. I understand. Any other point, Mr. Kole?
Milord, so far facts is concerned, Milord,
No, don't
so far point of law is concerned, your lordship is well acquired, my lord. On earlier judgment also, your lordship has said that there is a scope for disciplinary proceedings unless, my lord, 2, 3, 4, 5 principle violation of natural justice, rule of disciplinary proceedings,
Very good.
punishment is disproportionate. So your lordship is well acquired.
Very good.
I think, my
Take
lord.
down. The affidavit in reply as filed today
Lord,
on
may I
behalf of
take-
the
My lord, spacious lives.
He is an ideal employer. Why should he be
call the
deobliged?
next matter.
I'm deeply obliged to your lordship, my lord. Deeply obliged.
I'm grateful to your lordship. Sir.
Six, anybody? Make it not today. Not today. Oh, I see. Can it be taken up within, disposal within 10 minutes?
My lord, kindly, I am praying for some time to file a reply back. Affidavit in opposition.
Very good.
Will serve, my lord.
Your reply is ready?
No, my lord. No, only 2 weeks time.
Then, order the number. The affidavit in opposition as filed today on behalf of the respondents You know? Yes, call the next one.
I am for the petition.
I am for the respondent.
Lordship, as per your lordship direction, again I have served to the respondent number 5A substituted respondent lordship. I have filed both the affidavit of service together. Affidavit of service together.
Respondent number 5A.
Yes, lordship, substituted.
Substituted respondent number
Yes.
5A. Shrimati Shumita Das. You are
Yes,
representing her?
I am representing respondent number 6, my lord. Shankar Datta. Today, the first day I am appearing, my lord.
Ma'am, why here filing two affidavit of service?
Lordship, earlier question I have already served but misplaced the affidavit of service. Therefore, I am paying for filing reaffirming of the affidavit of service kept with myself. But your lordship directing to file a fresh notice to the respondent number 5A.
So which one is
There
the
are-
latest?
Latest is lordship.
This one or that one?
That one, lordship.
Oh, এটা কবে পাঠালো? The 20th November 2024.
Yes, lordship.
And it is
Earlier.
on 24th January 2000. So this one is the latest,
Yes, lordship.
which has been received.
Yes, lord.
লিখুন the two affidavit of service, two numbers of লিখুন two numbers
Item number 10, your lordship was pleased to take it on Monday, last Monday. Obviously, your lordship was a part of the division. I understand your lordship. One thing, but I have two formidable leaders above Mr. Petitioner and Mr. Basu. I was only one of the decision of lordship to fix that one date next week. Subject to your lordship, my London friend is also here.
Monday I shall be in, Monday I shall be with Justice Bakshi.
In the middle of the week, Wednesday, we'll take a try. It's subject to your lordship's convenience, my lord. If it appeals to your lordship.
What is the matter about?
Or it would take some time. It's regarding the Inland Fisheries Act. Even a particular section is under challenge also. It would take some time. Very candidly, my lord,
Probably you will
I might
visualize
take the
like predicament.
we will try our luck. I know that it is nobody's fault and lordship is always hijacked to a division bench. I know. Even my lord, I had mentioned few matters for correction that is not coming now. Anyway, if your lordship, বুধবার দিন হবে, বুধবার দিন কি সম্ভব হবে দেখুন শিডিউল আছে, ডেটটা ফিক্স হলে খুব সুবিধা হয়। ফাইল তো এখানেই আছে, আইটেম 10, আইটেম 10। আঠারো তারিখে Thursday, I'll advise the lordship. Actually, division bench is she was widely circulated. Can't tell. My lord, your lordship has been pleased to dispose of one matter just before the last day before the puja vacation. There is a small correction, and lordship's order was that to complete the demolition period within 3 weeks. I have not been able to place the file. To be mentioned. Second half of the criminal appeal. No read now. Read is the first half only.
My lord, may I be permitted to mention a matter, my lord, for inclusion in the list, my lord. This is a restoration application, my lord. My lord, this was execution case was dismissed for default, my lord, for non-appearance, restoration. I'm grateful, my lord. I'm grateful, my lord.
Newspaper applications, item number 1.
My lord, I am for the award holder in this matter. The execution has been stayed in and connected appeal under section 37 of the Arbitration Act. I am carrying the order of the division bench, my lord. Right, my lord. My lord. Yes, my lord, I am carrying the last order. Detailed notes have been filed. Arguments are due to commence. This is the last order, my lord. With liberty to mention, my lord.
I am appearing, my lord, on behalf of the decree holder in this execution proceedings, which arises, my lord, out of a commercial suit in a simpliciter claim for recovery of money lent and advanced. The defendant chose not to appear even in the trial of the suit, and my lord, it was an undefended suit, which ultimately, my lord, fructified into the decree dated 9th of August 2024, and my lord, it was modified. Only typographical errors were modified on September 2, 2024. Today, my lord, yes, my lord, your lordship kindly comes to page 30. My lord, kindly have a look at page 29. That is the operative portion. Since your lordship, my lord, is looking at the order, page 29 is the operative portion of the judgment, my lord. Paragraph, my lord, the decree is 9th August 2024, and my lord, it begins from page 22 to 29. My lord would kindly, yes, kindly comes to paragraph 22. Yes, my lord, 10 lakhs being principal amount along with interest at the rate of 12% per annum from the month of July 2022 till realization. Yes, 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 my lord. Yes, it is 2024, and decree is also, my lord, of 2024. It was filed, my lord, immediately. In fact, we filed it immediately. Yes, my lord, lordship wanted to see the modified order, modified decree. That is page 30, my lord. Yes. No, no, no. Only with respect to typographical errors. Yes. Yes. Yes, my lord. Now, my lord, kindly, yes, if your lordship kindly takes, my lord, the tabular statement. My lord, today I am praying before your lordship for prayers C and E. I am not praying for attachment at the moment. Prayers C and E. Yes. May I, my lord, kindly invite your lordship's attention to paragraph 8 of my application. Yes, my lord. My lord, we have a typed copy of the tabular statement at page 12. My lord, I was referring to paragraph 8, 7. Page number 7, my lord. May I please? As far as the plaintiff has been able to ascertain, the judgment debtor is in possession of and owns certain assets and properties wherefrom their decreed debts can be recovered. The particulars whereof are as follows. Now, there are two, my lord, immovable properties. Paragraph 9, the decree holder has also been able to ascertain that the judgment debtor number 1 has inter alia a bank account being account number such and such with Central Bank, Lake Town, Sector B, Kolkata branch. Another saving accounts bearing number such and such with Punjab National Bank, Sribhumi. Now, my lord, may I? Yes. Those two properties and this bank account. And the reason, my lord, because yes, my lord, they have to keep apart the decretal amount of which is, my lord, as on date. The lordship will find, my lord, the 10 lakh, 14 lakh rupees, my lord. Yes, my lord, may I just show two paragraphs, page 8, if your lordship kindly takes page 8, my lord. Paragraph 12 and 13, may I kindly place, my lord. The decree holder has reasons to believe that the judgment debtor is, my lord, 12 and 13. Yes, my lord, kindly comes to, I have shown the tabular statement. Please takes up page 12. Please takes up page 12, my lord. Page 12, my lord, is the schedule of assets, and we have a typed so that your lordship can easily read. C and E, page 13. An order of injunction be passed restraining the judgment debtors from selling and disposing. Very well, my lord. As your lordship directs, if your lordship passes the order under E, I will definitely notify the two banks. My lord, because I am not aware whether at all there is any money in those two accounts or not. I would also be praying, my lord, for affidavit of assets. That, my lord, your lordship will appreciate. And I was relying on your lordship's order. May I hand up? It's a very recently baked order, my lord, of 24th January. Lordship will kindly see. Over here, your lordship, my lord, has injuncted both landed properties, also bank account. At the outset, learned advocate for the decree holder draws attention of this court to the judgment and decree passed on in CA such and such, which was before. Yes. My lord will kindly. My lord will. Yes, my lord, that is prayer C. Order of injunction be passed restraining judgment debtor from selling, disposing, or alienating or dealing with in any manner properties and assets in paragraphs 8 and 9. 9, my lord, is the bank account. 9, my lord, is the bank account. Yes, paragraph 9 talks about the bank account. The decree holder has also been able to ascertain that judgment debtors number 1 has inter alia bank accounts at Central Bank and Punjab National Bank. So they should not, my lord, deal with this. But similar facts. The date of the decree, my lord, is also same. Ex parte decree. The amount, my lord, under the decree is 15 lakh. That is the only difference. The number of judgment debtors, my lord, are 4. Yes, 10 lakh was the principal, and it was also, my lord, modified by an order of September 2, 2024, which is at page 34. Here, my lord, the amount of interest is 15%. That's why there is a very small difference of 45,000 from 14 lakh. The earlier decree was 12%. And the ordering portion, my lord, is at page 32. No, there are, my lord, this is a partnership firm. Because, my lord, your lordship will find that in the earlier matter, one of the judgment debtor had taken the money in his independent capacity. Here, the partners have taken, my lord, in the name of the firm. So 10 lakh and 10 lakh, 20 lakh was, my lord, advanced separately. And this, my lord, now has been adjudicated through the decree. My lord, reference to paragraphs and reference to prayer numbers would be identical. Because over here also, my lord, in paragraph 8, I have mentioned the immovable properties. And in paragraph 9, only one bank account. Date of decree and date of modification, both are same.
Item number 5.
Lordship.
Lord, item number 5, I'm appearing on behalf of the decree holder. My lord, I'm being led by Mr. Kumarjit Banerjee, who's appearing online.
Your Lordship, I'm appearing for the decree holder in item number 5, Your Lordship. The decree, Your Lordship finds it at page 15. Upon judgment upon an application for judgment upon objection, a decree had been passed.
Sir, your
Sorry,
voice is not clear.
Am I audible, Your Lordship? Am I audible?
Yes, audible, but not very clear. Anyway, make your submission.
Your Lordship, my humble submission is I'm for the decree holder and a judgment upon admission, on an application for judgment upon admission, a decree had been passed on 10th of June 2024, Your Lordship. That is at page 15.
Page?
15, Your Lordship.
15, 15, 1-5. The operating portion of the judgment and decree is at page 21. This was a case for goods sold and delivered and price not paid. And there were certain admissions in the letters and email.
So what is the digital amount? 23 lakhs and 60,000?
23 lakhs 60,000, Your Lordship.
With interest?
Yes, with interest. At 10% per annum.
What is the date of the degree? June
10th
10,
of June
2024.
24. So I have filed this application for execution within 2 years, Your Lordship.
Very good.
So no notice need to be served. Today, I'm only praying for prayer B of my tabular statement, which is disclosure of affidavit of assets, Your Lordship.
What's your good name, sir?
Kumarjit Banerjee, sir.
Asun. What's your good name, madam?
Akanksha Chaudhary, my lord. Akanksha Chaudhary. My lord.
Whether any appeal has been, whether any, yes?
No appeal has been preferred, Your Lordship. I have
In the tabular statement, you have mentioned the digital amount.
My lord, it is mentioned under the prayers. The 10th heading, my lord, the first prayer.
Mr. Banerjee? Order
Yes, your lordship.
You are praying for appropriate order in terms of clause B, no?
Clause B. For filing of the affidavit of assets, your lordship. That is form 16.
Yes, yes.
And the decretal amount is specified. The decretal amount is specified in prayer A of the tabular statement.
No, আমার কথাটা শুনতে পারেন সেটাই বলছি। Stop para. It appears that the prayer as made by the degree holder is innocuous one. According degree holder is innocuous one. In view of such, the judgment debtor of the instant execution case is hereby directed to file an affidavit in form 16A of Appendix E of the Code of Civil Procedure, disclosing his assets and properties positively on the adjourned date, that is on February. That is on 7th March 2025, on which day the instant matter will be listed under the same heading.
Very deeply obliged.
Top para. Liberty is given to the petitioner to communicate the server copy of this order to the judgment debtor by speed post. The petitioner is further directed to file affidavit of service on the adjourned date.
Grateful,
Very grateful. Very deeply obliged. In item number 6, your lordship, for the decree holder, this is arising out of an interim order directing security to be furnished for an amount of rupees 14 lakhs. The order is of 5th of August 2024. That is at page 15. The operative portion is para 21 at page 21.
So there is a direction
for security
securing a particular amount.
Yes, your lordship, by deposit.
So how execution lies?
Your lordship, section 36 of the CPC makes the process of execution applicable to any order as well.
CPC টা কোথায় গেল? কালকে তো ছিল এখানে।
Your lordship, may I read the provisions of this code
Yes.
relating to execution of decrees, including provisions relating to payment under a decree, shall, so far as they are applicable, be deemed to apply to execution of orders within bracket, your lordship, including payment under an order. This is an order directing a payment. So under 36, the provisions of order 21.
No, is there any direction by the trial court to pay you some of such and such?
Pay, your lordship, may I read? But the same is dishonored, and in spite receipt of notices, the defendants are not contesting the suit, and the application thus is court taking into consideration balance of convenience. Parties direct the defendant number 1 to secure an amount of rupees 14,923,627 with the registrar original side of this court within 2 weeks. So that is a direction for payment to the registrar original side, your lordship. And I have other
If it is not, if no direction is passed for payment to the degree of plaintiff, how this order is becoming executable?
May I? There are decisions of this honorable court, your lordship, on precisely this point, that an order directing securing an amount by deposit in court is also executable. Your lordship will kindly make this matter returnable on the coming week. I will bring those judgments and show it to your lordship and satisfy.
But not in virtual mode, sir. It's very, very difficult to.
No, I will be present physically, your lordship. I will be present physically. My apologies. My apologies.
Just make it not today.
Very well. I'm deeply obliged.
Grateful, your lordship.
এটা রেখে দাও, ACPC রেখে দাও বাবা। Where is Mr. Shourjodip? He's on his leg, but he has a parted matter.
Yes, my lord.
Who will do? You will do.
I can continue, my lord.
You have to. No. What I'm on. Yeah. If you start, you have to conclude.
Conclude today itself.
Yes. Or you may take an adjournment, whatever you like.
Lord, I can take an adjournment. I can come back on Monday itself.
Very good. Give me a minute. Give me a second.
My lord, item number 58 and 51 are identical matter. Both are identical matters.
Criminal.
I am item number 81.
It is a criminal matter.
Yes.
Wait. What is your number?
81.
69.
68 or 69?
68, my lord. 68, my lord.
68 তো সূর্যদীপ ঘোষটা নেই এখন। 68.
My lord.
I'm just making it not today. Then এটা আবার কি হলো?
Deeply obliged, my lord.
Yes, which is why I'm only making it not today. You need not be worried, but it will be taken up on Monday. Yes. Call the next matter.
I am for the appellant. As per direction of your lordship, I have approached the department. They say that there is no paper book. Paper book has not been prepared.
No, it's a report. But a report is come, the learned advocate, but the appellant is yet to collect the paper from the department.
Well, I have approached my lord twice.
When you have approached, sir?
Twice, my lord.
When you last approached?
Day after tomorrow.
Day before tomorrow.
Oh,
but there is a report that on 13 to 2025 it has been just prepared.
Well, again, she will go at Monday. She will collect the paper book.
আসুন।
হ্যাঁ, দুবার
70, Mr. Taposh Kumar Ghosh appearing. My lord, he is busy in another court, my lord.
Not today. Mr. Samanto's case judgment has been passed or not?
My lord, what's it concluded hearing? But judgment has
Judge not been pronounced, no?
Other matter, 76, I have responded. 79, 24 years. 370, operate. I have responded.
No, one matter I have heard you. Judgment has not been pronounced. CAV. Very good. It will be pronounced very soon.
76, your lordship, my heart. 376.
376. Oh, midst of case. Yes, yes, I can remember. Very good. Yes, next call the next.
May please your lordship, pipe number 71, senior advocate Mr. Shekhar Kumar Basu is appealing your lordship was pleased to appoint me as an amicus on the
Yes, yes.
It's a EC Act matter, your lordship. If your lordship so desires, I can start off with them.
Yes. Madam is not present. I mean, making it not today. Mr. Basu has given a consent to proceed with you. Proceed.
This, on several occasions, I have to take time. That's why.
No, what I'm on, after your appointment, Mr. Basu appeared.
Yes.
And I requested Mr. Basu to keep you with him. So for my recollection goes.
Yes, your lordship.
So in absence of Mr. Basu, would it be better?
Matter, I can start off.
No, you know my mode of work. If I start, I cannot stop. Which is why I'm asking you. What the client's desire. That you will argue or the Mr. Basu will argue.
Clients have not contacted him as per my instruction.
Then Mr. Basu must be present. And otherwise, if any adverse order is passed, you will be missed.
Yes, your lordship.
On behalf of the state, and accommodation has been paid for.
Next week, my lord, we have some difficulties, my lord. If your lordship.
Second accommodation, I shall consider.
No, we will not be here, my lord. We both
of you are not going to be here.
Law clerk also. Say law clerk's son is.
You'll go to Kumbh. Go to Kumbh.
No, my lord, Benares, the marriage ceremony is there, my lord, so we'll be there.
70?
70.
Item number?
70.
এই তাহলে একটা কাজ করো বাবা, 70টাকে না মানে এটা মানে 2 weeks করে দাও।
I am deeply worried.
70টাকে তুমি একটা কাজ করো তো, মার্ক করে রাখো জানো, এটা নোট করে নাও তো। 70 নো?
Yes, 70.
নাহলে গন্ডগোল হয়ে যাবে।
No, I do not know.
Very good. Here come from
That's. Yes, come. If it was within our knowledge, my I should have beaten him.
Go on, calling.
76, I am the respondent.
Appellant is not present, not today.
7, 8, 59, 18, 1.
Respondent is not present today. Not today.
And for the applicant, item number 68 and 81 are both identical matters. The last occasion, your lordship has passed an order to keep the matter on 13th February. But the technical problem, I think the matter is trying to keep the matter to Monday, just after PRA 525, 26.
Those are case counter case. I am asking for that. Why didn't you mention to yesterday? The matter was hard at lab. It was argued by Mr. Ghosh. You didn't notice? দেখছো আমি তোমাকে কালকে জিজ্ঞেস করছিলাম যে কাউন্টার ম্যাটারটা কোথায়? You're fortunate that the matter is not concluded. If it is supposed to be taken up today, so একটা কাজ করো তো. Is item number?
Yes, 68 and 81.
68 তো পাঠার ম্যাটারটা ছিল, তাই তো? And 81, এই 81টা বার করো. It ought to have been mentioned when the item number 68 has been called for. So what is your predicament yesterday when the matter was taken up for hearing? Hearing was continuing for at least half an hour. বার করো দেখি. Actually, yesterday I was asking for the counter case. You are for the appellant. Did you see the paper book? Yes, Sridham Maji, yes, those are there. আসুন.
83, my lord, I am appealing for the appellant along with Mr. Day. On behalf of CBI, man, prefer an appeal. There is acquittal against acquittal appeal paper by
82 or 83?
83. 83.
CBI is the appellant.
Yes.
You are representing CBI.
Against acquittal appeal paper.
Who is for the respondent?
My lord, I am for the respondent, my lord. I am led by Mr. Jayanto Kumar Das, my lord. He is not present today for the medical ground, my lord. Kindly make it not today. Fix any date on the next week, my lord.
Very good. As per prayer made on behalf of the respondent, let the matter be listed on in the month list of March 2025.
Grateful, my lord.
Madam, 84 I am paying for not today.
87, my lord, I am paying 15 days time. I have received paper book yesterday. I have to prepare it myself.
Month list of March 2025.
Lordship, item number 87, I am for the state.
87 to 89 will go in the month list of March. ওই অর্ডারটাই করে দেবেন।
God bless me.
এইটা কি পড়ে রইল পথে কোনো?
What? I need to share the respondent. CBI.
Milord 92, Milord, I am for the appellant, Milord, I am led by Mr. Senior Counsel, Mr. Shekhar Basu.
Month list of March. Judgment against acquittal or conviction?
Conviction. This paper
You are on bail.
Bail. Man.
Lordship, 93, I am applying for the CBI, Lordship, but I have not received the paper book, Lordship.
93 filed apart home. '93 were for CBI.
Yes, Lordship.
Against an order of acquittal.
No, Lordship, I think it's against the order of conviction. I am appealing opposite party CBI.
Then you are standing in this side, why?
Oh, I am sorry.
Mr. Shekhar Kumar Basu, learned senior one, Mrs. Raj Nandini Das. Ashun, the appellant is not represented today, though it reveals Next. Next. Not today.
Your Honor, I am for the petitioner. In this case, I have been led by my senior A.K. Upadhyaya. He is out of station, so I am praying not today.
Month list of March 2025.
Obliged. Your Honor, can we kindly keep it on next Thursday, if the court permits? Upcoming Thursday.
It will be at the bottom. It will be better at March.
Obliged.
Your client is on bail, no?
Yes, Your Honor.
Lordship pardons me for mentioning at this time, Lordship, item number 80. In this matter, I am appearing for the appellant led by Mr. Ashok Biswas. Lordship kindly makes it not today.
80, 80?
Item 80, Lordship. 80.
Yeah, already made. I have not passed any adverse order. You are praying for not today only, no?
Not today only, Lordship.
Not today also.
I am appealing for the appellant led by Mr. Ashok Biswas.
Very good.
I am grateful, Lordship.
চলে গেছে